The Supreme Court will be taking up a gun rights case.
Major Supreme Court ruling.
Major ruling involving the Second Amendment.
All right, we've got this breaking news just coming into our newsroom right now.
So another unanimous ruling from the Supreme Court.
Within 24 hours, the highest court in America delivered a verdict so crushing it sent shockwaves through conservative legal circles nationwide. An 8-1 decision that didn't just reject a bold challenge to federal authority, it obliterated a legal strategy that conservative states believed would finally tip the balance of power away from Washington. Missouri had attempted something unprecedented, something no state had dared try since the civil rights battles of the 1960s. They constructed what they thought was an impenetrable legal fortress designed to shield their citizens from federal gun control entirely. The result wasn't the constitutional victory they imagined. It was a spectacular legal catastrophe that backfired so dramatically, even Missouri's own law enforcement officers became casualties. What unfolded represents far more than another routine court case about firearms. This was a constitutional showdown that exposed fractures within conservative judicial philosophy so profound that even the most right-leaning Supreme Court in nearly a century couldn't bridge them. And the implications reach far beyond Second Amendment debates into the very foundation of how federal and state power interact in America. Understanding what went wrong reveals why one justice stood completely alone, and what this means for every state contemplating similar resistance to federal authority. Missouri's legal architects didn't draft ordinary legislation. They engineered what can only be described as a financial weapon aimed directly at their own law enforcement agencies. The Second Amendment Preservation Act, commonly called SAPA, created a penalty system so brutal that sheriffs across 114 counties faced an impossible dilemma: cooperate with federal agents investigating gun crimes or watch your personal finances disintegrate. The $50,000 fine represented just the opening salvo of what legal analysts calculated could become total financial ruin. A single officer participating in multiple federal investigations could accumulate penalties exceeding $200,000 within 12 months. But the true genius, or perhaps madness, of Missouri's plan lay in its citizen enforcement mechanism. Any resident could transform into a legal bounty hunter, filing civil lawsuits against law enforcement agencies that dared collaborate with the ATF or FBI on gun-related cases. Within 6 months of the law's activation, 47 lawsuits flooded Missouri courts, creating a litigation nightmare that drained millions from already strained county budgets. The hemorrhaging came not from actual penalties being paid, but from the mere threat of endless legal battles. Counties burned through taxpayer money on defense attorneys, court fees, and administrative costs. What Missouri created wasn't protection for gun rights. It was a self-destructing legal bomb that exploded in the state's own hands, crippling the very law enforcement agencies it claimed to defend. Here's where the story takes a genuinely ironic twist. Conservative attorneys borrowed their entire playbook from the progressive sanctuary cities they'd spent years publicly denouncing. Between 2015 and 2021, over 560 cities and counties declared themselves immigration sanctuaries, successfully blocking ICE agents from accessing local jails, using municipal resources, or obtaining information from government databases. These jurisdictions established effective legal shields using something called the anti-commandeering doctrine, a constitutional principle the Supreme Court had repeatedly upheld. The doctrine is straightforward. The federal government cannot force state and local officials to enforce federal law. Constitutional scholars watch cities like San Francisco, New York, and Chicago create robust barriers against federal immigration enforcement through careful legal maneuvering that survived court challenges. Missouri's legal team studied every single sanctuary city victory, invested over $340,000 in research, and believed they'd discovered the perfect constitutional loophole. Their logic seemed bulletproof. If liberal cities could block ICE using anti-commandeering principles, conservative states could block the ATF using identical legal reasoning. But Missouri made one critical error that sanctuary cities had meticulously avoided, a mistake so subtle that even constitutional experts initially missed its significance. Once the Supreme Court identified this single miscalculation, Missouri's entire legal fortress collapsed catastrophically. When that 8-1 vote emerged from the Supreme Court chambers, it illuminated something remarkable about Justice Clarence Thomas that most Americans fundamentally misunderstand. Thomas has now stood alone in dissent or unusual positions 73 times during his tenure, more than any other sitting justice by a factor of 3. His judicial philosophy embraces originalism so strictly that he willingly overturns precedents enduring over a century if he believes they contradict the Constitution's original meaning. In the Missouri case, Thomas didn't even author a full dissent. He simply noted he would have granted the stay, which in Supreme Court language represents the equivalent of declaring that 8 other justices fundamentally missed something. Legal historians compare Thomas's solitary positions to Justice John Marshall Harlan's solo dissent in Plessy versus Ferguson, the 1896 case that upheld racial segregation. Harlan stood alone and was vindicated 58 years later with Brown versus Board of Education. Thomas's supporters believe he's playing an extraordinarily long game, planting constitutional seeds for future courts to reconsider federal power limitations. Critics argue he's become so ideologically rigid that he's lost connection with practical governance realities. But Thomas's vote wasn't actually about firearms at all. What he was defending carries implications extending far beyond Second Amendment boundaries into the fundamental structure of American federalism itself. Just 3 years before Missouri's spectacular defeat, the Supreme Court handed down the Bruin decision that completely transformed Second Amendment jurisprudence in ways most Americans still don't comprehend. On June 23, 2022, the court established a revolutionary test requiring any gun regulation to be consistent with America's historical tradition of firearm regulation. This standard threw out decades of established legal framework and replaced it with historical analysis, creating chaos in courtrooms nationwide. Within 18 months of Bruin, over 450 federal and state gun laws faced challenges in court. Judges suddenly had to become historians, examining musket regulations from the 1700s, dueling laws from the 1800s, and frontier gun policies from the Old West. The success rate of these challenges skyrocketed dramatically. Before Bruin, gun rights advocates won approximately 23% of Second Amendment cases. After Bruin, that number jumped to 67%. Lower courts struck down laws banning firearms in parks, churches, and subway systems. Age restrictions preventing 18-year-olds from purchasing handguns fell across multiple jurisdictions. Concealed carry prohibitions in 6 states were overturned entirely. Gun rights organizations filed over $89 million in lawsuits using the Bruin standard, winning far more often than losing. This raises a crucial question. If Bruin was already winning the war for gun rights through federal courts, why did Missouri feel compelled to create SAPA at all? Behind Missouri's extreme reaction lurked a federal agency that has become arguably the most controversial law enforcement body in America, and the statistics explain why gun owners harbor genuine concern. The Bureau of Alcohol, Tobacco, Firearms, and Explosives conducted 37,872 compliance inspections of gun dealers in 2023 alone, a 340% increase from 2016. These inspections resulted in revocation of 122 federal firearms licenses, effectively shutting down gun stores for paperwork violations that owners claim represent technical errors rather than criminal intent. The ATF has wielded regulatory power to reclassify items without congressional approval, declaring bump stocks to be machine guns and forcing over 520,000 owners to either destroy their devices or face federal felony charges. They redefined what constitutes a firearm to include partially completed receivers and frames, creating criminal liability for hobbyists building guns at home. Most controversially, the ATF maintains a database that, despite legal prohibitions against registries, contains over 920 million firearms transaction records. When gun dealers close their businesses, their records transfer to the ATF's National Tracing Center, where they're scanned and stored indefinitely. Gun rights advocates call this a backdoor registry. The ATF calls it crime-solving infrastructure. Missouri legislators examined these numbers and panicked, seeing federal agents with power to criminalize gun owners overnight through regulatory changes bypassing the legislative process entirely. But their solution created an even bigger problem that ultimately handed more power to the very federal government they were attempting to resist. Article 6, Clause 2 of the Constitution contains just 68 words that destroyed Missouri's entire legal strategy. The Supremacy Clause establishes that federal law represents the supreme law of the land, overriding state laws when they conflict. But Missouri's case becomes fascinating because they weren't actually attempting to override federal law. They were using the anti-commandeering doctrine, which the Supreme Court has repeatedly affirmed. States cannot be forced to enforce federal law, a principle the court established in Prince versus United States in 1997 when they ruled the federal government couldn't require state law enforcement to conduct Brady Act background checks. Missouri believed they stood on solid constitutional ground. The problem emerged in their language choice. SAPA declared federal laws invalid within Missouri's borders. That single word, invalid, transformed their law from non-cooperation into nullification. Nullification represented the doctrine Southern states attempted before the Civil War, claiming they could void federal laws within their territory. The North won that war, and the legal question was permanently settled. States cannot declare federal laws invalid. Missouri's attorneys insisted the distinction is purely semantic, arguing that refusing to enforce a law and declaring it invalid are functionally identical. The court sided with the federal government decisively. Here's the terrifying question keeping constitutional scholars awake. If Missouri had changed just 5 words in their statute, they might have achieved victory. That Supreme Court vote tells a story extending far beyond firearms, revealing a fault line in conservative legal philosophy that threatens to explode into open conflict. The 6 conservative justices include Amy Coney Barrett, Brett Kavanaugh, and Neil Gorsuch, all appointed specifically because of their originalist views and skepticism of federal power. Yet they voted against Missouri without hesitation, creating no close call or nuanced decision requiring extensive deliberation. This reveals that even the most conservative Supreme Court in 90 years maintains hard limits on how far they'll permit states to challenge federal authority. They'll expand individual gun rights through cases like Bruin and limit federal regulatory agencies through decisions like West Virginia versus EPA, but they will not allow states to functionally secede from federal law enforcement systems. The implications stretch far beyond the Second Amendment into the fundamental structure of American governance. If Missouri had won, red states could nullify environmental regulations, while blue states could nullify immigration enforcement, fragmenting the entire federal system into 50 separate jurisdictions with their own rules. The conservative justices, despite their states' rights sympathies, examined that possibility and delivered absolute rejection. Justice Thomas was willing to venture into that constitutional territory, which explains why he stood alone. His legal philosophy prioritizes constitutional structure over practical consequences, regardless of the chaos that might result. Meanwhile, other states are already rewriting their laws, using the exact constitutional language that might actually work. And if they succeed, everything changes in ways that will reshape the balance of power between Washington and state capitals forever. The Supreme Court just rewrote the rules of engagement between states and federal gun control, establishing boundaries that will influence constitutional law for generations. What comes next will determine whether the Second Amendment grows stronger or weaker in individual states, and whether the federal system survives the growing tension between competing visions of American governance. This conversation has only begun, and the next move belongs to states brave enough to test the court's newly established limits. That's it for today, folks. See you in the next video.